we have a problem. Our citizens have literally been priced out of the civil justice system. The cost and delay are such that many people do not have a meaningful access to the courts when they have a problem the courts need to solve. And this is, so they're not getting what our Constitution said they're supposed to get. People with valid claims, our system is so complicated, takes so long, so disproportionate to what's involved sometimes that many people just choose not to bring a valid claim because it doesn't satisfy a rational cost-benefit analysis. The same thing happens to defendants who get sued. They have to look at, I'm right. If I tried this case, I ought to win, but can I afford to win? So a lot of cases are simply either not being brought or settled or resolved on the basis of economics instead of on the basis of the merits of what's involved. And this is not justice. How did we get there? When I began practicing 50 years ago, this coming September, the rules were simple. The pleadings said what the facts were, what your legal claim was. They were somewhat too technical, but they seemed to work generally. The only deposition you could take was a deposition of your opponent, and unless somebody was not going to be available for trial, you could take anybody else's deposition. If you wanted documents, if you wanted a doctor's report, an expert report, if you wanted to go look at a wrecked car, you had the right to file a motion with the court, and the judge, if he thought this was necessary to the case, would order that to happen. The plain fact is that lawyers knew the judge was going to allow it in most cases, and the last thing in the world you wanted to do was to be remembered by a judge as somebody who was unnecessarily obstructive in litigation. There was literally, lawyers knew one another, the judges knew the lawyers, you knew you were going to be practicing with the same lawyers and before the same judges for your whole career. There was just this culture of respect and cooperation that made the system work. 1938, the federal courts adopted a uniform set of rules, and as the Federal Rules of Civil Procedure, and over the next 30 years, most states adopted those same rules. They made sense back then. The old rules did not often allow you to bring out all the facts, all the evidence. The federal rules allowed you, you had a lower threshold for getting into court in terms of pleading, and you had a discovery process that made evidence readily accessible. In the beginning, those rules didn't change the trial practice very much. They worked well, they had better procedures for gathering facts, and that culture of cooperation among lawyers and the court still existed, and most discovery was still done by consent. In 1970, I tried a major antitrust case. The government asked for all of my clients' documents on a particular, on the issues involved in the case. They were all in file cabinets in one office suite, and the documents they asked for didn't quite fill one file box. In the district in which I practiced, the two judges put cases on the calendar in the order in which they were filed, so you knew your case was going to be called for trial. When its number came up, you knew that was going to be not all that far down the road. In 1978, I tried a lawsuit that had involved, it was a national issue with issues with witnesses all over the country, so we had taken about 60 depositions. There were probably a couple of thousand documents that had been looked at. We tried the case. I've represented the plaintiff. We recovered what would be probably close to $200 million now. When that case was tried, it was 18 months old, and it was the second oldest pending case in the entire Western District of North Carolina. The oldest one was a patent case that had gone up on appeal and been referred back. So it's changed. When the federal rules were adopted, there were two ways to communicate: paper and orally. By orally, I mean either talking on the telephone or talking face to face. So the evidence, by and large, was going to consist of what was on paper, hard copies, or what people said. You know, it's a he said, she said sort of thing. You put the witnesses on the stand and the jury decides who they believe. That was a paper world. If you wanted more than one copy of a piece of paper, your secretary put a carbon and an onion skin in the typewriter and pounded harder. We weren't killing very many trees back then. Now, with computers, the internet, we literally have an information explosion. Emails, people don't talk anymore. They send emails. So if there's a piece of litigation where people have talked to one another by email, you have to go search all the emails. It's called electronic discovery or e-discovery, and it is eating us alive. There's also been a change in culture. From the time of probably sometime after the Second World War, at that point, there was sort of a moral consensus in our society. Everyone knew what the rules were. You knew everybody. You didn't have to lock your door or your briefcase. And the courts were the last resort in people's lives. If they couldn't agree, that's the civil courts, or couldn't behave, that's the criminal courts. And we started losing that consensus, and gradually we became a regulated society. ERISA, truth in lending, you name it. And at that point, the courts became the first arbiter of all our lives, instead of the last bastion if we couldn't agree or behave. And that called for a whole lot more lawyers. So the law schools started turning out hordes of young lawyers, all of them far better educated than I, coming out of law school with a set of weapons, every weapon known to man. I like to say an AK-47 in every briefcase. And not a lot of instruction in Judgment 101 when it's appropriate to use these procedural devices. And on top of that, there was a litigation explosion. There are hundreds of times more cases brought now than were brought 40 years ago, and yet we know that fewer cases are being tried. There are fewer judges to supervise that process. So the rules that worked 70 years ago really no longer work. You have a low threshold for getting into court. There's no way to force the parties to focus on what the real issues are. No judge to sit them down and knock heads and say, what's really at issue in this case? What part of it are you really serious about? How much discovery do you need to take? And how long will it take you? And how much will it cost? And when will you be ready for trial? And we're going to set a trial date at X time. That's just missing now. So discovery goes on unsupervised by a judge and without being focused on what's really at issue. And so discovery has become a war of attrition. And the rules that worked 70 years ago simply don't work anymore. And this is not just theory. I met a young couple recently. They started their own small business 10 years ago. They got in a fuss with their landlord who tried to go up on the rent in midterm, and they said no, so he locked them out, turned off the electricity. So they went to court and got a restraining order telling him to leave their business alone, and they brought a damage suit. It took them 2.5 years to get that simple breach of contract case tried. They saw at least 4 different judges in the process, no one of whom seemed to be, clearly no one of whom was in charge of the whole process. And the damages they recovered were less than their lawyers' fees. For bringing that simple, the system simply failed them. My civil procedure professor in 1957, in my first year of law school, was a great advocate of the Federal Rules of Civil Procedure, and he thought my state ought to adopt them, and ultimately they did. But one day in class, he leaned back and he said, "We did away with common law pleading because it simply didn't do justice. In the federal courts, they did away with code pleading because it was too hyper-technical and didn't do justice. Someday, you'll have to readdress and perhaps do away with the federal rules. After all, they're just tools. And you have to change with the times, and you have to make sure your rules work in the time where you are." So I'll come back to where I started. The epitaph on the tombstone of any institution that fails starts out but we always did it this way. And I think I am satisfied that we need to face the fact that the world has changed. We have outgrown these rules. And the worst thing we can do is to do nothing. We are literally pricing our system, our citizens, out of the civil justice system, and we can't afford to ignore the problem any longer.